This is the Government Perspectives panel, and this is the academics panel, or what I'll call the pedants panel. And as the presiding pedant, I would like to start this discussion by picking up on the debate from the last panel discussion as to what is or are the theories that underlie United States copyright law, because I think both Jay and Joe overstated their cases, or that they were both right to some extent and wrong to some extent, because the copyright clause of the Constitution, in fact, expresses both a utilitarian view of copyright and a natural rights view of copyright, where the language says to promote the progress of science by securing for limited times to authors the exclusive right to their writings. That word securing implies a pre-existing right. Congress doesn't make copyright up out of nothing. Congress reinforces a pre-existing right. That said, the incentive rationale is clearly in the clause as well, and in fact our copyright law oscillates between those two theories, even if the utilitarian incentive rationale is more often dominant than the natural rights rationale. But I think that there are things about the United States copyright law that cannot be explained purely by an economic theory, and they were voiced, I think, quite eloquently this morning by Doug Wright, that copyright does two things for creators, we were told this morning. One, it pays them, at least we hope that it pays them, so that they can afford to continue to be writers. And two, it allows them to protect the integrity of their works. It protects their dignitary interests in their works, not through a distinct moral right. Joe is quite correct that apart from VARA, we do not have a separate moral rights regime. But we do have the exclusive right to authorize the creation of derivative works, that is, alterations to the work, and if the author retains the copyright, the author can use the derivative works right to protect the integrity of her work. So she can use an economic right to protect a moral interest. So our copyright law, in fact, combines both of these concerns, of these aspirations. One other feature of the copyright law, which I think is best explained by a natural rights concept rather than a purely economic concept, is the author's reversion right, which has been in our copyright law from the start. Indeed, says that the Congress shall have power by securing for limited times, plural. The plural there probably to the English statute of Anne, which we plagiarized in the copyright clause in our first copyright statute, because the author's reversion right actually came in with the statute of Anne. And the reason for the author's reversion right was that while Parliament was legislating in an intellectual environment of the Enlightenment and strong natural property rights theories, so that the work is vested with the author when the author creates the work. Nonetheless, we all know that authors enter into bad contracts and they give up their copyright, and so they do not see the economic benefit often of their copyrights. And the whole idea of the reversion right was that the author should get the rights back. Now, the reversion right, it doesn't incentivize the author to create the same work, right? That work is already created. Maybe it provides a higher level incentive to create more works in general. But as to that work, it's already been created. If the author gets the rights back, it's because we have some notion that she created it, it's hers, and she ought to be able to see the benefit from that. So I think, just by way of framing the pedants panel, that it's useful to acknowledge that we have really two themes that underlie our copyright law, and indeed two themes that have been voiced by a number of the speakers throughout the day. The speakers on this panel are all distinguished academics. I invite you to read their full biographies. I will simply give their affiliations. We will first hear from Eva Subotnik, who teaches at St. John's, but I will amplify her bio to say that she is a graduate of Columbia Law School and was the very first Kernochan Center Intellectual Property Fellow. She will be followed by Molly von Houweling, who teaches at Berkeley, and finally Danielle Gervais, who teaches at Vanderbilt. So they will each speak for up to 12 minutes, and then we will turn to kind of dialogue or interaction between the panelists, and finally, for the remainder of the hour, to all of you. So with that, Eva?
Well, thanks very much, Jane. I'm going to flatter myself by saying that I clearly have my finger on the pulse of the discussion here today, which is really just a nice way of saying that I realize that lots of what I'm going to say are going to raise themes that have been discussed in prior panels. But I do hope to make my own contribution and add my own spin through the prism of being a legal academic. So one of the toughest things, I think, about asking how to make the copyright system work better is, as many have said right from the start today, generalizing about what is not working. And so in these brief remarks, I want to identify 3 areas that demonstrate this difficulty in generalizing. Now, I have to offer my own disclaimer, which is that I took the animating theme of this symposium to be improving the financial stake of individual authors in some kind of a direct way, I guess hitting on primarily on one of the theories of copyright rather than the other, but also distinguishing the possibility, which I think we've already heard is kind of a hard thing to generalize about, improving the financial stake of individual authors by way of improving the financial stake of Hollywood studios, record labels, publishers, etc. So with that assumption in mind, here are the 3 contexts I want to discuss that really reflect this difficulty in generalizing. One is the issue of which kinds of creative activity should properly be the focus of the copyright system. Second, the issue of copyright's application to the internet, which is, of course, both a catalyst for and a detractor from profitable authorship. And third, the issue of the costs of litigating infringement claims. So let me begin now with the first of these 3 themes, generalizing about authorship. We saw a little bit, some of this hint earlier today with the discussion about that some segment of our population create for, I think David, I'm not sure where he is now, but described this as creating for social relationships, something other than economic benefit. Situations arise, right, from time to time where there is a lack of clarity over who is an author to begin with, a term that the statute obviously does not define. There's been a lot of recent fanfare over whether monkeys can be authors, but leaving that aside, there's arguably some inconsistency over who is an author and, by extension, who should benefit financially from the copyright system. So, for example, one appellate court refused to find authorship in a wildflower display created by an artist, Chapman Kelly, in Chicago's Grant Park, acknowledging that Kelly had selected his species of flowers for, quote, aesthetic reasons, that the defendant had actually marketed the display as a, quote, living landscape art, and that Kelly's garden could be classified, quote, as a work of postmodern conceptual art. The court nevertheless found that the garden was too much a product of natural forces, which distinguished it, the court suggested, from a work like Jeff Koons's Puppy. Now, perhaps this one failed authorship bid need not trouble us. Indeed, the thrust of that case seemed to be about the artistic control over the garden's future, again, touching on the other theory, rather than securing financial rewards for the artist. would be wrong to infer a trend toward denying authorship claims. Another appellate court, as we heard alluded to earlier, recently found likely protectable authorship in a brief acting performance by an aspiring actress, Cindy Lee Garcia, because her actorly rendering of 4 pages of script was at least a minimal creative contribution to the underlying film. Accordingly, this recent decision might make those in favor of ensuring financial reward sanguine by signaling a broad opening for a whole new class of viable authorship claims. And yet I think such an open-ended, capacious approach to authorship is not necessarily a victory for the interests of professional authors. The Cindy Lee Garcia case had nothing to do with the enforcement of copyright as a legal tool to ensure creative livelihood. Furthermore, the court really fell into the same formalistic approach to assessing authorship as did the Kelly court, both avoiding the question of whether these plaintiffs were creative professionals who were likely to have been motivated by the copyright regime in undertaking their respective creative activities. Moreover, the court in the Cindy Lee Garcia acting case did not, I submit, fully appreciate the practical consequences of expanding authorship, that in the future it may come at the particular expense of small budget directors and producers, that is, those who do typically rely on copyright, who must now be concerned about preventing fractured copyright claims to their films. That is, I think when the questions of who is an author or what is an act of authorship become untethered from the overarching goals of copyright, it becomes harder to shape law and policy toward assisting that subset of authors who actually rely on copyright to make or at least to supplement a living. Okay, so second, generalizing about copyright law's application to the internet. We've heard a lot about this already. Congress established the DMCA, the Digital Millennium Copyright Act, in part to stimulate the architecture that would support and permit robust growth in online distributed content by setting up safe harbors for internet service providers. And as we've also heard, and I think it's important to keep in mind, as many of you know, but still to emphasize it, that many creators today are obviously beneficiaries. They benefit a great deal from the visibility and word-of-mouth publicity that they can achieve that wouldn't have been possible in an earlier day. In particular, it means that individual authors can market themselves without the help of gatekeeping distributors who would otherwise exert certain kinds of creative control, as well as taking a cut off the top from profits that are in fact generated. And yet, as we've heard again, time and again today, it's clear that the role of the internet as a business platform for individual authors is a mixed blessing, a lesson that I think sometimes gets lost in the prominent cases that have litigated the DMCA's provisions. Many of these cases involve corporate copyright owners suing service providers of various sizes. And so the kinds of fact patterns that emerge, such as the expectation that copyright owners will file thousands upon thousands of takedown notices with service providers, that might be the most efficient solution in view of the resources of larger copyright owners in terms of monitoring the use of their works. Likewise, the judicial interpretations that have gained traction, such as requiring that ISPs know or be aware of specific instances of infringement before they are disqualified from safe harbor protection, are especially justifiable where the aggrieved parties have the resources to regularly notify ISPs of specific infringement. But as has been said as well, the burden allocation starts to look differently among authors, ISPs, and users when the relevant copyright owners are individual authors. For such smaller operation creators, the ability to spend hours per day, as we've heard, submitting takedown notices is simply not feasible. And I think it's important to underscore that with policymakers, that if the overall goal of the copyright system is to encourage and allow creative types to support themselves by being creators, that it's counterproductive, hugely counterproductive on a policy level if the takedown notice procedure deprives authors, smaller-time authors in particular, of the resources that they would otherwise be allocating to the creation of new works. Furthermore, I think it's tempting but imprecise to generalize about the main types of uses that copyright owners are unhappy about. So we typically hear about complaints about direct commercialization by the service provider itself through driving ad revenues, for example, or non-commercial uses by youthful sorts who either just want to consume content or want to express their creativity by posting remixes within members of their own community. But I think it's important to remember that there is a third category besides direct commercialization by the ISPs and non-commercial uses, and that is commercial uses by corporate entities who discover copyright owners' works on the internet and then bring them out into and exploit them in the bricks and mortar world in a commercial setting. So I found an interesting essay by one photographer who is commenting on this. He specializes in high-quality photographs of insects, and he recently put forward his view in an article on Ars Technica that maybe some of you saw. He said, "Let me indulge in a list of recent venues where commercial interests have used my work without permission, payment, or even a simple credit. Billboards, YouTube commercials, pesticide spray labels, website banners, extermination trucks, T-shirts, iPhone cases, stickers, company logos, ebook covers, trading cards, board games, video game graphics, children's books, novel covers, app graphics, alternative medicine dietary supplement labels, press releases, pest control advertisements, crowdfunding, promo videos, coupons, flyers, newspaper articles, postage stamps, advertisements for pet ants." Yes, that's a thing, he says. "Canned food packaging, ant bait product labels, stock photography libraries, and greeting cards." All examples of sort of uses that typically fall out of the main kinds of uses that are discussed, namely this third path, right, commercial uses by corporate entities that small-time authors are upset about. So I think at a deeper level, all of this really reflects difficulties about let me put it this way. I think generalizing about the role of the internet in supporting and hampering creative livelihoods really touches on larger problems of generalizing about the general nature of infringement today. That is to say, in a number of instances, high-profile lawsuits by individual creators have been directed at users of their works by other individual creators. So whether we're talking about something like the Carew v. Prince case or Salinger v. Colting, these cases get a lot of press in part because the facts are easy to describe and the cases raise colorful and important disputes about how the copyright system should apply when the issue is the creative needs of author versus author. But those high-profile contests can really manage by individual authors is in fact directed squarely at straightforward commercial use, often bread and butter stuff, such as use beyond the terms of a license. Okay, so third and finally, generalizing about the cost of litigation, I think there really is a serious and significant imbalance in the perceptions of the costs of litigation in the enforcement of rights. We've heard a lot today so far about, which I fully agree with, that most individual authors cannot credibly threaten a lawsuit today. Even the Copyright Office recently cited a statistic estimating that the median cost for a party to litigate a copyright infringement lawsuit with less than $1 million at stake through the appeal phase is $350,000. But on the other hand, there is another side to this. There are those who are genuinely and rightly concerned about copyright creep as a force stifling free expression of those who interact with copyrighted works. And they point out how unpredictable it can be to gauge the sorts of uses that will elicit a cease and desist letter from aggrieved copyright owners. So in a sense, we find ourselves at another standstill in which once again, it's hard to generalize. Copyright litigation, on the one hand, is sort of ready to leap out and crush expressive reuse at any given moment, and on the other hand, is totally out of reach for the ordinary author. From either perspective, it's hardly acting as an optimal tool for ensuring reasonable compensation for authors. Furthermore, the hope that one can use litigation with the hopes of, at the very least, gaining name recognition, as I suppose Patrick Carrier did by the end of the day, that's for most authors going to be very wishful thinking. So what lessons can we draw? Unfortunately, as is often the case, right, I'm afraid that most of what I've succeeded in doing is raising questions rather than law-driven solutions about helping professional authors monetize their creative works. But the main thing I hope that I've underscored is that I agree with those who have said that a one-size-fits-all approach to copyright does not seem to serve the cause of individual professional authors. In that regard, I think any legal initiatives that assist in differentiating the different kinds of authors and owners could be very helpful. One example of this that's been discussed, and I hope we'll hear more from Cy at the Copyright Office about, is the possibility of the Small Claims Tribunal, as well as perhaps tailoring the burden allocations under the DMCA framework. And finally, this was hinted at earlier, I think possibly the elimination of the requirement of timely registration for works in order to preserve rights to statutory damages with respect to certain kinds of uses or certain kinds of authors might be an interesting idea to explore. So I'll stop there, and thank you.
Thank you very much. Molly.
Thanks, Jane, for having me. I study at Berkeley the impact of copyright on individual creators and the impact of individual creators, both amateur and professional, on the copyright system by studying how they use copyright and how they manage their works. I also study the idea of copyright as a property right. I teach both property and copyright, and I'm one of those intellectual property scholars who thinks that there are very valuable lessons to learn from the law of property about the right scope of copyright, about the right duration of copyright, about the systems for keeping track of copyrights, which I think should better mirror the systems that we have for keeping track of tangible property rights in land and other resources. Now, I also consider myself an author, as do my colleagues at Berkeley and I bet the other academics on the panel. Although most of us don't make a lot of money, we certainly don't make our livings from selling copies of our books. Nonetheless, authorship is one of our job requirements, and control over our works is therefore key to our professional success, and copyright is an important part of that control. Thinking about how important copyright is to the lives of academic authors, some of my Berkeley colleagues and I have helped form an organization called Authors Alliance that represents academic authors and other authors who are concerned with managing their rights in ways that ensure that their works can be read. I was tempted to wear my Authors Alliance t-shirt. I resisted that temptation. I did bring some brochures in case anyone wants to know more. So our mission, helping authors who really want, above all, to be read, it's not a mission that is at odds with the idea of making money. But it does recognize that whether a book or article makes money or not, whether it once made money and isn't making money anymore, whatever its status commercially, we want it to be accessible to the public in a way that contributes to our intellectual legacies, if not to our monetary legacies. So you might ask, what could possibly be the obstacle to that? Surely the internet, which authors can use in creative ways, as Eva has suggested, makes it possible for any of us to choose how accessible we want our works to be. In theory, that's right, but in practice, it's often not right for reasons that T.J. Stiles alluded to this morning and that we've heard echoed throughout the day, including in Jane's remarks. So the problem is that academic authors, perhaps worse than any other authors, often sign away their copyrights without thinking about the consequences. And there are consequences later. When they find themselves wanting to reuse their works, to bring out-of-print books back into print, to anthologize them, to collect the greatest works of my scholarly career, or even having given up on making riches out of selling copies of these works to just put them on the internet for people to read for free. But of course, the authors who have signed away their copyrights don't have the authority to make those uses of their own works. Maybe they can get that authority back by renegotiating with their publishers, but these absent-minded professors can't tell you what their contract with their publisher said, where they put it, who that publisher is. The publisher might have gone out of business and be impossible to find. This is an ironic twist on the orphan works problem. So orphan works, those works where the copyright owner can't be found for purposes of asking permission, in many cases the person who wants permission to use the work may be the author. The person with the strongest claim to parenthood over that work, nonetheless, the work as a matter of copyright law is an orphan work and they can't get the permission to use the work that they want to. Now, of course, academic authors were absent-minded professors, but we're not alone in these dilemmas of authors and artists wanting to reuse their own work. Doug Wright told us about that this morning when he reported that he didn't have the right to use his own writing from a film in a subsequent revision of his own play. So what could help with these dilemmas? Well, there are a few things in terms of copyright reform that might help. For one, as we've heard again and again today, it would help to make record-keeping work better for authors. In particular, it would help if there were a requirement that transfers from authors and other artists to publishers and other intermediaries be publicly recorded, so that we can at least go back and remember who it was we transferred our copyrights to. Jane and Danielle, among other copyright scholars, have made specific proposals along these lines. So that will help us keep track of our rights in case we want to get permission to use our works in the future. Now, of course, that would require some renegotiation. So you have a good recording, you can figure out who has the rights to your work to open up negotiations. Something that would make those negotiations easier, or maybe even not require negotiation at all, is simplifying and improving the termination of transfer right, referred to by Jane more generally as the reversion right. Both of these things, improving recording and making termination easier, are among the principles and proposals for copyright reform that the Authors Alliance has put forward. So, incidentally, is a small claims process, which we've also heard lots of enthusiasm about today. Now, something I'll say that is not in the Authors Alliance proposal specifically, but which I favor and which I think might help Doug in his situation, is simply putting a thumb on the scale in any fair use analysis if the user is also the author. So I would want it to be the case that it would be fair use, maybe not for anyone, but for Doug, to use little bits of dialogue owned by someone else in his own reworking of his own play. To me, the right to revisit and revise your own work should be among the moral rights that we care about and incorporate in the law somehow. So those are some copyright reform ideas, but I think we can also improve the situation, again, as we've heard throughout the day today, by educating authors about their rights. Here at Columbia Law School, the Keep Your Copyrights project aims to do this, to educate authors about the importance of keeping their copyrights and managing their rights that way. Authors Alliance hopes to contribute to this education as well. So one step that we're taking right now, we have a group of law students at Berkeley Law working on surveying our members to understand better what their practices have been with regard to their publication contracts, and in particular, whether they have had reason to try and renegotiate those contracts, perhaps to exercise an out-of-print clause in their contract, or otherwise to get rights back in order to do a variety of things with their works. We hope that the end result of this survey and information gathering will be to help authors do that with educational materials explaining to them what some terms in their contracts might mean, perhaps model form letters, model contracts that help them exercise and renegotiate their rights. Now, we're inspired in all of this by the success stories of some of our Authors Alliance members, and I'll mention just one. One of our members is Katie Hafner, a longtime staff writer at the New York Times, who is now an independent journalist, also a non-fiction writer of books and memoir. She has a current memoir, Mother, Daughter, Me. Back in 2008, her book was A Romance on Three Legs, a sort of biography, although much more than that, of the pianist Glenn Gould. It was a well-received book. It was reviewed in a review called A Musical Version of Seabiscuit. Katie wanted me to mention that, the musical version of Seabiscuit. That sounds good, right? It's called A Romance on Three Legs. So right this minute, if you want to read A Romance on Three Legs, published in 2008 in print as opposed to an ebook, it's not available. And Katie, at the beginning of this year, was heartbroken by its unavailability. She wanted her work to be read, and to be read not just by tech-savvy people who could get the ebook version, but by classical music fans. I think she imagined a bunch of old ladies, Glenn Gould fans, who wanted to read her book, but they didn't want to read an ebook, they wanted to read an actual book. Katie didn't have the rights to publish an actual book on her own because she had assigned those rights to her publisher. Fortunately, with the encouragement of Authors Alliance, she was able to renegotiate with her publisher, which has now brought back a small print run of A Romance on Three Legs. And so soon it will be available both in ebook form and in hard copy form. Now, there are other authors among our members who have almost the opposite problem. Their books are available in print, maybe at least in used copies, but they've given up on selling copies of their books. They just want to make them available for people to read and want to use the internet to digitize them and make them available that way. But here, too, they don't have the rights to do that and want to see how to renegotiate with their publishers. Now, in many of these cases, the books have outlived their commercial lives. So the publishers probably wouldn't care one way or the other about whether they're made digitally available on the internet, and we're having some success renegotiating with publishers in some of these circumstances as well. But it's really not worth a lot of the publishers' time to think about giving permission to digitize this old stuff. They've moved on to the new books that they're bringing to press. So we hope at Authors Alliance that we can lower some of these transaction costs by highlighting best practices, by putting together some model language, by consulting with authors. We can make it easier for both publishers and authors to come to mutually beneficial solutions to these problems where books, whether they made money or not, are not being read as well as they could be. So that those who do rely on selling books can be paid, but there aren't unjustifiable obstacles to being read.
Daniel?
Thank you. Well, first, thank you, Jane and June, for the invitation. I'm very happy to be here. I want to spend just 10 minutes on the diagnosis of why it's so hard to fix copyright. I have detailed proposals for reform, but it would take much more than 10 minutes to explain them. If you have the courage, you can look at my testimony before Congress last year, or even more courage, my law review articles, and see what actually the proposals are. Also, a word of warning, I don't use PowerPoint. I use different software, which I refer to as the Six Flags version of PowerPoint, so you might find it moving a little bit. Okay. So I call it a tug of norms because that's really what's going on now. And so let's start with the familiar story that we heard, and not just today, that we hear all the time about the internet, right? The internet does a number of great things. It gives us access to almost every cultural product in pretty much any format. We can then modify and disseminate the modified version of that content. So it's kind of having the great library, which is this is what on the bottom, what it was supposed to look like in Alexandria, according to experts. But anyway, this is what it looks like on the upper picture. It's it's your laptop. So basically, I've referred to the internet here as the global meme factory. Basically, we access what somebody else has written or created in some other form. We copy it. We copied it because we want to read it or because we want to modify it. If we modify it, we'll disseminate our version, and the cycle repeats. So there's a great advantage for authors. obviously, you don't need to go through a professional distributor. The filter of having to have your agent find a publisher who will actually want to publish your book is gone. You can self-publish. You can put your songs directly on the internet. You can produce them at home with Pro Tools or some other $200 software. You can obviously produce documentaries and so on. And the filters that the publishers were in the past are now look like stars. So if you get 5 stars, you're really, really lucky. Of course, then you get a lot of content that looks like this. Aww. Okay. And so, so what really has happened is there's actually music that goes with that, but okay. So there are 3 examples here of the type of professional content providers that are now competing with free, or let's call them more specifically ad-based distributors of content, all kinds of content. The new distributors don't really care that much if the content is amateur, semi-amateur, professional, and I say unaffiliated because I mean by that professional authors who are not working exclusively with one professional distributor. And obviously what they care about is the hits, right? How many people will actually want to watch this cat video is important. This is a really important part of why we have a problem. The old professional model was based on access scarcity, right? So there was a limited number of books, so you had to pay to get to the book. You had to go to the bookstore, DVDs, CDs. You had to get to the theater and buy a ticket, and fortunately you still do, mostly. TV and film had release dates, so there was control over the media. That's all essentially gone. There's a re-intermediation via search engines and other internet tools, and that changes a few things. What is now the scarcity is not physical scarcity, it's the ability to be found, the ability to connect your content with people who actually want to listen to it, watch it, read it. I call it like scarcity, and this is the like I'm stealing from Facebook and all these others. What creates value is not physical scarcity, it's the user time and preference to find your stuff, so they have to find it, and then they have to like it. Like it as the word like is in the dictionary, but like it as Facebook would also have it. We're here to answer this simple question. So is it working? For authors, right? So to this I say, okay, well, which authors? Because the problem we have is one size fits all copyright. So let's just name 4 types of authors. Molly just spoke quite eloquently about scholars. And they definitely have one piece of that policy pie. There are those who just seek to be visible on the internet for whatever reason. They're not known yet. They want to test the market. I call those pre-market works. It's kind of horrible, but those who just want to promote. There are professional authors. We heard from 2 excellent ones this morning, whose income actually depends on people paying for their works. But they work with different industrial constraints, by which I mean if you're in film or radio or something, the situation will be different. And then there are those who are just sharing. And that's not just the amateur people. There might be people who don't think they can make money. And I really like Doug Wright's speech this morning, the part about parents and parenting. And I'm actually writing a paper on this now, but you know, some authors actually see their works as children in a way. I'm using it in quotation marks, but we do say orphan works, so we kind of use the metaphor in reverse. And to this I ask, okay, well, do authors have parental responsibility over their work? Do we recognize that? And if we do, well, then we have to give them the rights to be the parents, right? And when does that do? Is it just attribution? Is it integrity? Is it the right to get paid, the right to control? And the thing is, it changes for every type of author. So we need to adapt. And yes, it's a paradigm shift. The paradigm has shifted. I'm quoting, this is McLuhan, so it's old, but it sounds like it was written yesterday. To treat new media as humble servants of our established conventions would be as fatal as to use an X-ray unit as a space heater, right? So that kind of says something. So how do we adapt? Well, there's these theorists who say, well, forget about authors. Machines will create. The post-human creation movement, right? There's a good quote here. We are not the bounded, autonomous, coherent, fully self-conscious beings imagined by the Enlightenment thinkers. We're cybernetic organisms joined in continuous feedback loops, feedback loops, feedback loops, feedback. No, okay. So, okay, just thought I'd had, but it's Friday. Okay. Does this mean that I'll just take my face off now. Okay, so does this mean that human authors cannot or should not get paid? And by paid, I mean money, because the question is whether attribution does payment enough. We heard enough today to know that the answer for a lot of people is no. And then we heard Eddie Schwartz say, well, if it generates money, shouldn't I get my share of this pie? So there are two major arguments I want to talk to in the last 5 minutes that are used against paying authors for the use of their works. And let's just see if they apply and to which categories of authors. So it's true, undoubtedly, that some authors do not expect monetary rewards for the publication of their work. Ergo, some say, we don't need copyright. To this, I say there are at least two responses. One I call the temporal response, which is it's true that when authors, a professional author, sits down to write, most, I would guess, are not thinking, I'm going to make money with this, I'm going to make... They're in the creation moment, right? But to be in that moment, they have to be there in that moment, not at another job, right? So there is that need to have the revenue. So there's a temporal problem. The second is categorical in the sense that there's some categories of authors to whom this does not apply. So do we make entire copyright policy because there's some categories to whom this statement, for whom this statement is not true? And there's also this idea that new creation now is increasingly based on pre-existing content. And so there's an argument that is valid that copyright gets in the way of some of this recreation or modification. There's a doctrinal response that I could spend a lot of time on, but it's really about adapting fair use. What is the limit of fair use is what we really should be discussing here. So really the question is, can we make policy to accommodate all the categories of authors, including professional authors? So quickly, three issues why this has been so difficult. One is the unfairness in digital distribution. This is just the music example from this morning. The 28-to-1 ratio, if you're the author, that's a big issue, which I attribute in large part to regulatory capture. The statute just doesn't make a lot of sense here, so we would need to fix that. Then we need to figure out how we deal with the reuse paradigm. And the problem we have is the Copyright Act was created on the idea-expression dichotomy, which is you can use other people's ideas, but not their expression, at least not to the same extent. Well, the tools we have now are actually making it much, much, much easier to reuse the expression than the idea. You just cut and paste, you just copy, you just take. Finally, we have all the new case law that access, I call it access fair use, which says that to provide access is to transform. And there's great value, and Judge Chin talks about that in the Google Books case. But they don't mean transform the work, really. They mean transform access to the work because it's easier to find, it's easier to search it. But that impacts business models. So the authors have these three big changes to deal with, and they impact the different categories of authors differently. And it's not just about economic fairness or distributional concerns, what Mr. Schwartz called the 97th, or which I'm calling the 97.3 issue that Eddie was mentioning. It's the cultural issue that I think we should bear in mind. So to wrap up, my point is that copyright rules are obviously contingent. We can make them, we can break them, courts can make them and break them, obviously Congress can. But my point is we need rules that will make it possible for professional authors to continue to do what they do, which means they need to get paid when their work works. I'm calling it market-based living. If the work nobody wants, well, okay, that we could have government subsidies, perhaps that's another discussion. But in terms of copyright, if your work is downloaded or streamed by 1 billion people, you should be able to afford a little bit more than a pizza. So one-size-fits-all copyright has created this tug of norms because there are different types of authors who expect different things from copyright, and I'm suggesting we need to move away from one-size-fits-all. And at the risk of sounding a little over-dramatic, you know, we always kind of assume that change means progress, and Constitution says progress. I'm wondering, as a species, are we going forward if we lose professional authors, if we don't have the art and the literature and generally the things that make us better people. And I think we need people like whom? People like this man. And by the way, on the previous slide, that's Anthony Trollope, who was, why his picture? Because he got up every morning and wrote for 6 hours, right? And he produced a lot of books. You may or may not like them, but he produced a lot of books. This other gentleman produced a lot of books, got up in the morning, wrote books for 4 hours, went for a swim, and got, no, I won't say the last part. But I'm just hoping that when he wrote this, he wasn't talking about copyright. You know, for him, it was a dark passage which led to nowhere, then again to nowhere, once again to nowhere, always and forever to nowhere. Thank you.
Thank you very much. To all the panelists, and we have 10 minutes. So my first question is, do any of you wish to respond to anything that any of the others said?
Well, I have a question for Molly. Or anyone in the audience who has experience, actually. But my impression was that, at least with respect to some publishing agreements, that if the book went out of print, that the rights would sometimes revert to the author. And I'm wondering if you can speak to how frequent that was the agreement, or how frequent the example you were raising is actually the agreement.
So one reason that we're doing this survey of our members,
Okay.
and I hope that we can make it broader, is to find out more about the prevalence of different types of clauses. And Jane knows plenty about this, I'm sure, also from the Keep Your Copyrights Project and her other research, so I hope she'll intervene as well. But it is true that some book publishing contracts contain a clause that says when the work goes out of print, the rights will revert to the author. So that's a nice solution to some of the problems that I've described. It's outlived its commercial usefulness, so now the author gets to do what they will with it. There are a number of issues. So one, at least some contracts don't have that clause in them. Two, we're encountering questions about what it means for a work to be out of print. Many older contracts don't specify what that means with regard to ebook publishing. Some newer contracts do specify, but in a way that's pretty one-sided, that make it very hard for a work to go out of print under those definitions, so long as it's available for anyone to buy in an ebook form. And of course, some contracts don't have these provisions at all. So this project that we're doing right now at Authors Alliance is to look kind of retrospectively at what people see in their publishing contracts today. We're also interested in helping people look prospectively at what kinds of contracts they should sign for the future. So thinking about what an out-of-print clause should mean in the digital age is something that we hope to work on too.
I think that's a pretty complete catalog. It bears mentioning that the out-of-print clause was really for publishing contracts, so it wasn't for all copyright grants. And the other thing is that the standard clause did not result in an automatic reversion. The book had to have been not on sale for a certain period. The author had to ask that the publisher put the book back, and then only if after a certain period the publisher had not put the book back on sale would it be considered out of print, which plays into the question of what does it mean to be out of print, because now publishers can say if the book can be available in digital form on demand, which means that if for 3 years nobody asks for it, but we stand ready and able to provide a print-on-demand version, so one person asks at some point, it's not out of print. So that's part of the problem. But I think we have 5 minutes. Can I request? Where's June? Can I request an extra 5 minutes for audience participation? Yeah. Okay. If there is an extra 5 minutes worth of questions. So, Alan.
Have there been any cases where the contract is silent, that has an out-of-print clause, but it doesn't cover ebook because it was prior to ebook? Have there been any cases which clarify that?
Well, I'd say Rosetta versus Random House certainly is a case that interprets an older contract. It's not about an out-of-print clause, it's just about what rights were assigned in the first place, and says that in that case, an older contract that did not specify did not assign the electronic rights, and so they were held by the author.
These microphones don't work here on this row. Molly, in regards to your desire to create some licensing history, a repository of licensing history, at least in the visual space. The PLUS Coalition, useplus.org, is working to that end, and is in the midst right now of creating a registry, a new registry, and has already created the schema for the actual history, and that would be something that would be available by mutual agreement between rights holder and client, and they'd be able to go in and actually look at the licensing history.
Any other questions?
Yeah. So Daniel, what does different sizes for different authors look like? I mean, how would you have a regime that would be acceptable that would achieve that?
Well, so as I said, there's a long list of proposals, but some of the obvious one is to tailor remedies first of all, and so I have a paper on recordation that would make it different whether the original author owns the work, in which case you would have remedies with no formalities, but as soon as somebody else buys your right, you would have some sort of recordation, which the large media companies use. We heard that just the previous panel regularly, but it would also allow people to follow chains of title, which has really been an issue. I think the rights reversion clause is an interesting thing that could be expanded. There are also, in terms of fair use, I think we need to. I think the 4 criteria are well intended, and there's certainly a lot of history behind them. But the fact is that 96% of the cases since ACUF rose have used the word transformative when there's a fair use case. So everything's transformative now. So I think we've kind of lost a little bit the sense of that there's only this one big doctrine that has to do a heck of a lot of work now. So I've proposed some, especially in the congressional piece, there's a lot of specific reforms of fair use and of the rights. I mean, there's a long list of things that you can do. The problem is we're bounded by international convention problem. It's not necessarily a problem. There are great advantages to them too, but there are constraints through international norms that limit quite a bit in terms of rights and exceptions what we can do. So it's a very long answer, which I'm happy to continue offline if you want, but I could stop here.
Yes. Yes, Mark Ostrom, a practitioner primarily in the music business. I'd like to follow up on the question of fair use and what particularly this panel thinks of the recent Seventh Circuit decision, which seems to call into question the use of the transformative use test in determining fair use.
Well, that decision, which had to do with a mayor who was upset about his photograph being used in a kind of a political campaign that he disagreed with, and he somehow, I guess, persuaded the photographer to sue as a plaintiff in that case. But it was really his interests that were at stake, as I understood it. I don't know that, that the decision comes out all that different than the analysis would have in the Second Circuit, with which the Seventh Circuit perhaps tried to part company. But on the other hand, I don't think it's a bad idea to, kind of remember the statute. And I think emphasis on market effects is an important consideration. There were no particular market effects here, and I think that fourth factor is really one that should not be downplayed in terms of assessing fair use.
Part of Eva's point also makes me think of a proposal that I think Molly made, which is maybe we should see who is trying to enforce the copyright. And you were talking about who's claiming fair use. But in the Wisconsin case and also in the Ninth Circuit case about the news magazine that ran the wedding pictures, My against Mange magazines or something. There, the complainant wasn't the author. The complainant was a celebrity who acquired the copyright from the photographer and was really using the copyright to advance an interest that is not a copyright interest. And I think that those are actually quite good candidates for fair use, that fair use, since at least the Howard Hughes case, has been a bulwark against abuse by copyright owners who aren't the author and who aren't really advancing authorial interests. So I think that's actually quite traditional fair use and is not a sign of the expansion of fair use. There's been plenty of expansion of fair use, but not in that case. I thought I saw another hand. Jay?
Daniel, your point about authors who don't anticipate certain usage, does the contractual theory of unjust enrichment kind of fit into your thinking at all as to this possibly is the source, how authors could be paid in ways that they never anticipated down the road, and that we should look at that as kind of a bottom line foundation?
Yeah, it's funny. So I actually published a paper with a bunch of people on unjust enrichment, and one of my colleagues came to my office. He said, "Paper on unjust enrichment, huh? You must be in trouble." What the reason that I think the doctrine has a bit of room to grow in the United States compared to other common law jurisdictions where it actually does quite a bit more work, you know, the fact is that it's always thrown at the end of complaints now, and so it's how realistic is it? I don't know, but again, I can refer you to a paper where we discuss it kind of, but basically the paper says that it would be for the fairly extreme cases, the cases that are just not the run-of-the-mill, but really the case that is outside the bounds, and then you would need some remedy, and that the court have access to, restitute those kind of remedies, but it's not very successful typically in U.S. litigation. That's the problem.
I think that we have to cede the table to the next panel. So I'd like again to thank all of our academics, not pedants, and please give everybody a round of applause, and we will switch.